and that would be facilitated. But we are asking members of the committee to try to be as concise as would lend to us being effective still and efficient, given the time constraints. And our second presenter, for instance, the Child Care Board, is scheduled for 11:30. Given that we are starting just a few minutes after the intended 10:15, give or take 15 minutes or so, but we would not want to keep presenters waiting for inordinate lengths of time. So once we are comfortable, we can begin with the first presenter, and I think this is the stage at which we will be going live.
Press that.
Good morning, Dr. Evelyn and Ms. Edwards. Welcome. The members of the Joint Select Committee, before which you are appearing, wish to express our thanks to you at the onset for responding to the request to offer comment on two very important pieces of legislation that are being considered for proclamation, specifically the Child Protection Bill and the Child Justice Bill. The committee has had the opportunity to examine your written submission. And further to that, we are happy this morning to have the opportunity to hear you present, to have you present and elaborate on the submission. While I continue to give you an opportunity to settle, I take the further opportunity to introduce members of the committee. My name is Tony Moore. I am the chairman of the committee. You met Deputy Chairman Senator King earlier this morning as well. Other members of the committee are Senator Canon Reverend Dr. John Rogers. And next to him, we have Senator Dr. the Honourable Chelston Brathwaite. Online, we have the Honourable Corey Lane and other members attending the meeting today, the session today, are, we have to my right, next to the Deputy Chairman, Ms. Sean Bell. She is representing the Chief Parliamentary Counsel. She's Chief Parliamentary Counsel acting. To her right, we have the Honourable Kurt Humphrey, who is the minister responsible for the ministry that will be overseeing the Child Protection Bill specifically, and his permanent secretary, Mr. Jehu Wilcher. The other members that you see in the room are the staff of Parliament that will be supporting the committee. To my left, we have the Deputy Clerk, and next to her, Deputy Clerk. So, yeah. So, hopefully, you are settled in our invitation to you. You are prepared, I'm sure, to make your submission. The time allocated for that submission is 15 minutes, but I think you might recognize that the chair will not be unduly unreasonable, and we look forward to your submission. So at this point, I turn over to you. I should make you aware that the session is being streamed, so members of the public are also able to witness what is being discussed here this morning. So I turn over to you without further ado, and we welcome your submission.
Thank you, Madam Chair, committee members, fellow Barbadians. I'm grateful for the opportunity to speak on behalf of the children of Barbados with respect to the Child Protection Bill 2023. My name is Veronica Evelyn. I've worked with children and families for over 30 years. For the past 19 years as a consultant sociologist, I've conducted social action research and have trained trainers in Barbados and the region in the area of HIV and AIDS, health and family life education, and intergenerational poverty. Prior to this, I was a social worker in family services, welfare department, and then a school guidance counselor for 14 years. Now, there is definitely a need to update and reform laws pertaining to the care and protection of children. Children need protection because their powers of reasoning and self-control are still developing. Experts tell us that their brains are not fully developed until their mid-20s. Children are vulnerable, sometimes with a follow-fashion mentality that predisposes them to believe things and to make decisions which bring instant gratification without thinking of long-term consequences. And so, Children need to be protected, not just from people and situations that would harm them and affect their present and future well-being, but sometimes they need to be protected from themselves and, sadly, even from parents or the state. Article 2 of the Charter of Barbados expresses our commitment to the children of Barbados, and it says, understanding who children are and the critical role they have in our present and future, we shall prioritize, protect, guide, nurture, heal, and love all our children. How beautiful. The care and protection of children aims to safeguard their total well-being and to help them to appreciate themselves, their friends, their family, their society, so that they enjoy childhood and grow up to be emotionally healthy, well-adjusted, productive citizens who are able to carry the country forward. So an up-to-date Child Protection Act is quite in order. However, I submit to you that the Child Protection Bill 2023 is unacceptable in its present form. The bill can't be examined in a vacuum. It must be understood with reference to the local and international socio-political context in which it is framed and in which it will be implemented. The bill forms part of the revisioning and the reshaping of a Barbados as a new republic that wants to be counted among the progressive nations of the world in the way it treats the human sexuality. This was made clear in the September 2020 throne speech and reaffirmed in the approved Charter of Barbados 2021, which references the new concept of sexual orientation. Excuse me. The question, therefore, is whether the Child Protection Bill intentionally aligns with the vision of a progressive Barbados. And the only rational answer is yes. A no would indicate an internal contradiction, an incongruity between the bill and the vision and core values articulated in such things as the throne speech, the Charter of Barbados, the National Grooming Policy, the school's nutrition policy. Now, there are several areas in which the bill is problematic, but in this submission, on behalf of the children of Barbados, as a sociologist and as a firm believer in the supremacy of God and the continued relevance of Jesus Christ and biblical teachings to society, I'll look at 3 areas of concern. And these are: 1, the purpose of the bill, the language of the bill, and the lack of definition, or rather, the lack of clarity of definition of critical words and phrases as used within the bill. Section 3.1 states that the purpose of this bill is to ensure compliance with UN and other international instruments. These instruments forcefully promote new ideas about human sexuality, such as the belief that sex is non-binary and includes male, female, and any number in between, and that gender is fluid and can be changed at will. And these are the twin concepts that underlie the notion of sexual orientation, which Barbados seems to have embraced. By stating that its purpose is to ensure compliance with international instruments, the bill tacitly commits Barbados to satellite status. Yet, Article 5 of the Charter of Barbados puts things into perspective, and it says, let me read it. Barbados is part of a global community, and strong international relations with other states is vital to national development. As a small island state, we must exist harmoniously with others and work collaboratively to preserve global public goods. Listen to this. We will honor our international obligations while championing the causes that are important to safeguarding the future prosperity and stability of Barbados and the Caribbean. Consistent with this, the primary purpose of the bill should be to ensure the well-being of Barbadian children, not to ensure compliance with international instruments. It would be more fitting that the purpose of the bill reflect a pride in national sovereignty. For example, it could say something like, and this is just my little thing, the purpose of this bill is to ensure that the children of Barbados are nurtured and protected in an environment that enables the wholesome development of their unique personalities so that, to the fullest extent possible, they enjoy a safe, happy childhood and grow up to be well-adjusted, productive citizens able to contribute meaningfully to the long-term sustainable development of Barbados. We don't have to ignore our international obligations, but by all means, we must put Barbados first. The language of the bill is also worrisome. Over the past few years, language has taken on a new dynamism. There's a core of words and phrases whose meanings have expanded. For example, the words justice, dignity, equality now have very different interpretations than they did in 1948 when the Universal Declaration of Human Rights was crafted. One man's meat is another man's poison. One man's terrorist is another man's freedom fighter. It's a similar thing with the language of the bill. Depending on one's views regarding the concept of sexual orientation, the very same childcare issue may be assessed as either protection or abuse, cruelty or care. One person may see an issue as a matter of care and guidance or care and protection, while another sees it as neglect and abuse or violation of parental rights. Depending on perspective, the same issue may be seen as harming a child or as securing their health and their happiness. Given this fluidity of language which permeates the bill, until the country firmly decides where it stands regarding sexual orientation, any legislation that even remotely touches on related issues will be susceptible to self-serving interpretations. I therefore recommend that the language of the bill be revisited with a view to preempting unintended interpretations that would be inimical to the well-being of our children and our country. Another problematic area is the lack of definition, or rather the vague definition of critical phrases such as Section 3.1e, the best interest of the child, 3.2b, the capacity of a parent to properly discharge his parental responsibility, 3.2c, the physical, mental, emotional, or psychological needs and development of the child, 3.2d, the appropriate care or treatment required to meet the needs or development of the child. Section 4A, the safety and welfare of a child. Now, taken together and in the context of 3.1, Section 3.1, these subsections logically lead to questions such as, according to Section 2B, can the state consent to gender-affirming surgery for a child on the advice of a doctor without a parent's approval? Does parental responsibility include the responsibility of a parent to allow a child to change his or her gender if it's felt that this is needed to fulfill his mental, emotional, psychological needs and development? Can a care order be made with respect to parents who are deemed abusive because they do not support a child's belief that he or she is living in the wrong body? Section 5.1 outlines reasons for which a child may be in need of care and protection. In Section 5.1f, what does moral danger mean? What does section 51H mean? And I will read it here. It says that the authority has the power to remove a child if that child suffers from a mental, emotional, physical, or developmental condition that requires treatment to cure, prevent, or ameliorate the effects of the condition or harm suffered, and the parent does not or refuses to obtain treatment. Now, tell me, what does that really, really mean? These are some of the troublesome sections of the bill that conscientious citizens like Ms. Felicia Dujan have persistently queried with respect to parental rights vis-a-vis the rights of the state. In the absence of clear definitions and within the context of compliance with international instruments, provisions of the bill are open to tailored interpretations. And this is no straw man. There's ample evidence to support such a claim. Consider, for example, the details of the Bowden decision of February 2019 in the Supreme Court of British Columbia, or the September 2021 ruling of the Supreme Court of Western Australia in the case of TM9. In both cases, there were legal wranglings based on the fluid interpretations of some of these very words and phrases, and I have made those documents available to you. Also consider the recent ruling regarding the Montgomery County Board of Education guidelines for gender identity. These guidelines permit school officials to develop plans to support the transitioning of children and to withhold this information from parents if they are deemed to be unsupportive of the transition. These and many similar rulings and judgments indicate the challenges that will inevitably confront the country if the Child Protection Bill is enacted without clear definitions of critical but vague and ambiguous words and phrases. Soon finished. During the COVID-19 pandemic, the mantra was, follow the science and act out of an abundance of caution. The same approach is needed with the Child Protection Bill. Committing to the dictates of international instruments that espouse non-biological concepts is to abandon science. To enact a law without acknowledging the destabilizing social issues which similar laws have caused in other countries is to act without necessary caution. In proverbial terms, the choice is clear. The country can sensibly look before it leaps, or it can try to close the stable door after the horse has bolted. It's strongly advised that in all new legislation concerning children, the country act out of an abundance of caution. But if we insist on embracing the concept of sexual orientation as expressed in the Charter, and that is now being considered for inclusion in the new Constitution, then at least let's do so with our eyes wide open to all the ramifications. The Bible says, a prudent man sees trouble coming and takes cover, but the naive keeps on going and eventually pays the price. Let's not be naive. I urge the relevant authorities to revisit the Child Protection Bill, reconceptualize its purpose, review and revise language, so that the provisions of the bill are consistent with an informed, well-reasoned national stance on sexual orientation. In all things, Barbados and the children of Barbados must come first. As stated in Article 5 of the Charter, while we honor our international commitments, we will champion our own causes in our own betterment. Revisiting and revising the Child Protection Bill 2023 is critical to safeguarding the future prosperity and stability of Barbados. It is also necessary for the true protection of our children who are our future, the ones who will carve the character and culture of our new republic. Thank you.
Thank you, Dr. Evelyn, for your submission. As we examine it, first we will turn to Chief Parliamentary Counsel, because there are a number of aspects of your submission that would challenge legal aspects in the way the bill is presented, specifically along the lines of the purpose of the bill, the language of the bill, and what you classified as a lack of clarity of certain terms of the bill. So, Ms. Bell, over to you for initial response.
Good morning to the members of the commission. Good morning to all, and good morning, Dr. Evelyn. Just acknowledging your submission. Just to make some observations in relation to the interpretation of legislation, so that the interpretation of legislation is actually dictated by a number of materials, including the Interpretation Act, which gives some insight into the way that legislation is supposed to be interpreted, as well as common law positions that are decided in cases that would also elucidate how legislation is also to be interpreted. So that some of the conventions, as I will say, are articulated within legislation. So for instance, in the Interpretation Act, in the Law Revision and Law Reform Act, in the Constitution itself, those things have a bearing on how this legislation would be framed. And so it is with this understanding that you need to approach the legislation and how it is to be constructed. In terms of the purpose of the bill, I would take the opportunity now to indicate that you would have highlighted 3.1 and specifically 3.1a. But if you take into account that the subsection would have other clauses, so that A, B, C, D, and E are also to be included. And that is stated when you use the word "and" in the penultimate paragraph. So the penultimate paragraph in 3.1 is actually D. So that in full understanding of the purpose, you would have to take into account the fact that it is to ensure the compliance with United Nations Convention on the Rights of the Child, Universal Declaration of Human Rights, and all other instruments to which Barbados is a party, and that is very important, a party. Then there are other parts of it that are stated. Then you have to read in, promote the welfare of a child, provide the care and protection for a child, and notice that care and protection is further articulated in 5. And then finally, protect a child from abuse and neglect, and also ensure the best interest of the child is given paramount consideration in all matters. Now, in clause 2, you would see that best interest is defined, and best interest is defined as referring back to 3.2, which gives an explanation of what is considered to be in the best interest of the child. So clause 3.2 actually goes into, in determining what the best interests of the child are, the following matters shall be taken into account: the safety of the child, the capacity of the parent to properly discharge his parental responsibility, the physical, mental, emotional, and psychological needs and the development of the child, the appropriate care and treatment required to meet the needs and development of the child, where appropriate, the views of the child, a secure place for the child, a positive development as a member of a family, the love and affection and ties between the child and persons in the life of the child, the capacity of persons other than the parent to exercise custody and rights and duties in relation to the child, and the continuity of care for the child, and the possible effect and disruption of the care on the child. So if you read the entire purpose, it is from 3.1a to b to e, and then certain parts of the phrases have in fact been defined. So that this is something that you would have to take into account in understanding the entire purpose of the legislation.
I would have taken that into consideration. In fact, I went back to the Child Care Board, which this is, Child Care Board Act, which this is replacing. And let's look at section 3.2b in the bill, and then section 5 in the Child Care Board Act. The bill talks about parental responsibility. And remember, we talk about the one man's meat is another man's poison. Parental responsibility can be anything, because some people see, and when we look at the Bowden case and the Montgomery and so on, some people see parental responsibility as affirming a child in a delusion. Other people see parental responsibility as helping a child to change their gender to accommodate that delusion. But let's look at this.
Sure.
3.2b talks about parental
Sure.
responsibility
Dr.
in
Eaton?
general terms, yeah?
All right, just a minute, because for the purpose of clarity, this is like a conversation, so we
Okay.
would allow, rather than another presentation, for CPC
No,
to...
I was actually
back.
answering about the two sections.
Okay, it
So-
seemed to the chair, sorry, that
Oh,
you had gone on to
sorry.
something else.
No, I'm so sorry. So that 3.2b talks about parental responsibility. Now, in section 2, as you rightly pointed out, this is on page 14, it includes the rights and duties, just as it's defined in section 5.1 of the Child Care Board Act. I think that's page 9. But then it specifies powers, responsibilities, and obligations that by law a parent has in relation to a child. That is a broad, open statement, and it's an example of how linguistic ambiguity can facilitate a sort of self-serving definition. So on the one hand, we're looking at law, and on the other, we're looking at language.
Okay, Ms. Bell?
Yes, Chair, let me take the opportunity to indicate that when you're using the word law in legislation, this is supposed to refer to enactments that are passed in Parliament or through delegated power to a functionary, whether it's a minister or other type of functionary, to make subsidiary legislation. So that's enactments. Law also, the term law also refers to the case law that would be coming from the courts, so that when you are interpreting rights, duties, powers, responsibilities, and obligations that by law a parent has in relation to the child, when it says law, that is what circumscribes how it is supposed to be interpreted. So all the rights, duties, and powers, and responsibilities and obligations as set out in law meaning enactments coming from the Parliament or set out in SIs, as well as those cases that are coming out of the courts. That is what that use of that language means, and that is how it will be interpreted. Thank you.
Members of the committee, anything at this stage?
May I ask a question, though?
Certainly.
I was wondering, is the drafting of this child protection bill, because when I look at it in its entirety, and especially the language and the purpose, I wonder if it was entirely homegrown or if there were external influences that sort of shaped the drafting of the bill.
I think your submission to the committee recognized that any bills or contemplation must be taken within context, not only local but international and so on. But before I turn it to the drafters to respond, CPC to respond, what I would wish to ask of you is if you accept the response given that in law refers specifically to enactments and also cases that are judgments that have come down from the courts.
I do understand the differentiation. I am not a lawyer, and I like to stay in my lane. I'm a sociologist. I cannot argue with law.
Right, so much of what your submission has proposed concern with, though, are arguments in law. So it is important to get the responses in law so that the interpretation for sociologists and laymen like me is better understood. So CPC, would you wish to continue?
Yes, Chair, and just to underline the commitments that Barbados has made in relation to the international conventions, it should be observed that Barbados, now the main underlying international convention would be the UN Convention on the Rights of the Child. Barbados has been a signatory, has been a party to this, yes, has been a party since the 1990s. So it signed on to the convention on 19th of April 1990 and ratified the convention on the 9th of October 1990. The weight that should be given in terms of the signing on of the convention is, or the ratification is as follows, that a state that ratifies one of the international human rights treaties, of which the Convention on the Rights of the Child is one, it assumes the legal obligation to implement the rights recognized by the treaty. Though through ratification, the state undertakes to put in place the domestic measures and legislation compatible with their treaty obligations. The objective of stating the above is to indicate that Barbados, since the 1990s, has committed to implementing rights as recognized by the treaty, and the bill is only a further recognition of that commitment. That being said, the state can enter into a reservation on a treaty. A reservation is a declaration made by a state which purports to exclude or alter the legal effects of a specific provision of the treaty in their application to the state. A reservation enables a state to accept the multilateral treaty as a whole by giving it possibility of not applying specific provisions which it does not want to comply. Reservations can be made at the time of signature, ratification, acceptance, approval, or accession. Article 51 of the UN Convention on the Rights of the Child makes provision for reservations to be made by the state at the time of ratification or accession. Barbados at the time did not have any reservations, that is at the time. However, if there are any protocols that may come along that may seek to amend the said convention in a way that we do not agree with, the state, does not agree with, it can enter into a reservation, or it could just not sign at all. These are the parameters and the rights of the state as a sovereign. And I just wanted to point that out as well. Thank you.
So is it possible And would there be something wrong in stating the purpose in such a way that we placed Barbados, this is a child protection bill. So could the purpose be, the focus be on children and on their, this is in line with Article 5, on their contribution to the long-term sustainable development of the country? I am very concerned about this because you know what Errol Barrow said, friends of all, satellites of none. We want to, we're New Republic, we want to, have that national pride. Our purpose is to look after ourselves, our children, so that they can carry our country forward. This bill talks a lot about psychological health. So I would like to look at the psychological health of Barbados. When I take up a bill and I see the purpose is to comply with international instruments, I don't feel good about myself. I want to see me, I want to see Barbados, but most of all, I would like to see the children being up front and center in that purpose. I defer to the lawyer. I do not know if that is possible. Is there something wrong in revisiting and reconceptualizing and rephrasing that purpose of the bill so that we signify a sense of national sovereignty?
I think that CPC will respond, but as you contemplate the purpose of the full title of the bill is a bill entitled An Act to Make Provision for the Reform of the Law on the Care and Protection of Children. So this is really the context within which the bill is before the Parliament of Barbados, an act to make provision for the reform of the law on the care and protection of children. So of course the Charter expresses overarching interests and objectives as it relates to children, but the bill before us is very specific, and that's a layman's view, but CPC will pick up on further explanation.
Yes, Chair. As I would have explained before, you cannot take A without taking B, C, D, and E, which were articulated in the bill. So that's the first thing. And the second thing is that the said international agreements, etc., they are speaking to the international norms that speak to care and protection and and respecting the rights of the child. So from that perspective, you would not be able to argue that the legislation is not child focused. It includes the guiding principles that are consistent with the UN Convention on the Rights of the Child, the child participation, paramountcy of the best interest principle, key procedures in care and protection processes through investigation and placement. It recognizes the need for care planning and helpful guidance in general approaches to child protection procedures. It also establishes a new and much needed court orders to assist in protection, rehabilitation, and reintegration of children, and recognizes the intersection between children in conflict with the law and children in need for care and protection, and that it's its overlap with the Child Justice Bill, so that it would be difficult for you to argue in law that it is not child focused.
Yes, and I'm coming here from the point of view of a sociologist and as a linguist of sorts, because I did do a master's in sociolinguistics. And I did mention, if you look at my submission, I did look at section 1E, section 3.2, C, D, E, and section 4. So it's not what is said, it is the interpretation. I would suggest that we look for a while at the cases that I brought to you, the one in Western Australia, the one in Canada, where these very words and phrases, the best interest of the child, people saw it as different things. And that is the problem that we are going to have to face. The best interest of the child can be one thing, if I think that there is such a thing as sexual orientation, and quite the opposite. So even though this is a child protection bill, we know that protection on one side of the fence is actually seen as abuse. Care is seen as cruelty. Harm is seen as health. Do you understand the kind of problem that we are putting Barbados in? We are just open, out to sea. We have to decide, and I mean, we are a democratic country, we can decide what we want to decide. What I am saying here is that whatever we decide should be well informed, very well reasoned, so that, you know, the French existentialists talk about homme de bonne foi, that whatever we decide and whatever we do, we are able to bear the consequences, that's all. But right now, we are kind of just blowing in the wind.
Chair, just to indicate, and I would have explained earlier, the interpretation of legislation is governed by specific conventions and rules. And so you would not be blowing in the wind, it's not free for interpretation, but that those conventions as reduced or codified in the Interpretation Act, in other pieces of legislation, as well as cases on the particular matters, those have to be taken into account, as well as the parameters set by the bill itself, which appear in Clause 2. Those then anchor how the legislation needs to be interpreted. And I need to emphasize that as much as possible. And I also have to point out the fact that you need to interpret Clause 3.1 in its entirety and respect the fact that it has been interpreted and defined in the things that you're concerned about, that best interest of the child. Clause 2 goes into that. Care and protection, Clause 5 goes into it. In addition, I did look at your cases. I will say to you that, well, from Australia and the Canada point of view, now those cases, they would have persuasive weight, but they would not be considered to be binding. And in the understanding of how the medical treatment would come up in the first place, it arises in two specific circumstances, and I will draw your attention to that. It has to be looked at in context. So in the definition of care and responsibility in Clause 2, it authorizes the authority who would then be given the custody of the child after the child is deemed to be needing of care and protection. They authorize the authority to consent to medical treatment not involving surgery for a child on the advice of a medical practitioner, or consent to the medical treatment involving surgery a medical practitioner certifies in writing to be carried out as a matter of urgency and in the best interest of the child. In the second instance, it talks about delegated care responsibility, which is where the child is in the custody of a child care center, in which case then it would have the limb A, consent to medical treatment not involving the surgery for a child on the advice of a practitioner. So you would see that the authority then has more weight in terms of what they can decide. Right, okay, so just to finish the point, right. So that in the circumstances that you would have brought, when it talks about as a matter of urgency, Now, if a word is not defined within the legislation itself or anywhere else, it would take on the ordinary dictionary meaning, meaning that it would have to be that the medical intervention would have to be for immediate action, so that even if you look at the circumstances in the case, you would have seen that they would have had to subject the child to all kinds of tests, and there was all kind of going around to say, you know, well, what is really happening? That is not immediacy. That may be urgent, but it's not immediacy, right? This is talking about immediacy, right? So the thing is that it's for immediate action, so that they can make the appropriate decisions in the proper time. So I'm just pointing out to you how this will be interpreted. And I need to make pains to specify to you that the cases that you would have raised are persuasive but not binding. So they may even look at it, but they have to look at it in the grand scheme of things, where you're talking about the circumstances that obtain in Barbados. That is why that you can't just say that it will be interpreted any old how, but that they will be grounded by all the matters that I would have stipulated to you. Thank you.
Senator Brathwaite, I recognize you for an observation.
Thank you, Chairperson, and good morning to all. Chair, I would like us to express to Dr. Evelyn our thanks for her presentation and for taking the time to review and to express her opinion on the bills that have been brought to our attention, and to express that it is important that in our consideration of these documents, that we obtain the widest possible input, especially from persons such as Dr. Evelyn, who is a sociologist, and others, to help us in our deliberations and to help us to fashion a bill that is relevant to Barbados today and for the future. I listened carefully to the intervention of Dr. Evelyn, and she made two important points, in my opinion. One, that the bill must emphasize the well-being of the children of Barbados and not compliance with international obligations. Chair, during our meetings, we've had the opportunity to review both of these bills. And I am convinced that while they do take into consideration international context and international obligations, these bills are focused on seeking to do the best for the people and the children of Barbados. In establishing an authority to provide for the care, protection, and rehabilitation of children, to investigate complaints, to remove the child from homes where the child's welfare may be threatened, to monitor the operation of child care centers, to issue guidance for child care centers, to establish with approval of the minister policies and procedures respecting all aspects of child care, to provide for consultation and direction to relevant authorities respecting the care of the child, promote and safeguard this. All of this is set out in Part 2, Administration of the Child Care and Protection Bill. And there's much more that I could go on to mention which is referenced there. In addition, of course, in Section 5, the bill sets out very clearly the conditions under which the state should intervene in the need, care, and protection of children. I must state that while it is true that the bill focuses substantially on our local reality, it does take into consideration the international context. And the international context, Chair, in my opinion, is not developed in a vacuum. The international context is developed by the United Nations, where there are representatives today of maybe 192 countries, in which international opinion, international circumstances, international experiences are discussed, and on the basis of that, an international convention is developed, where countries can then agree or not agree with the final preparation. So in the United Nations, Barbados is represented. And therefore, our representative would have an opportunity to participate in the dialogue and the discussion that takes place in the formulation of international standards, international conventions, bringing to bear the experience of Barbados and the experience of 192 other countries. So international standards are important. They give context, they give relevance, and they bring best practices to the table that may be relevant to the development of our legal systems. So the international context is important. But let me go back and say that this is a bill that focuses on the future of the children of Barbados and the relationship between the children, the parent, the home, the teachers, the society, the community, and how we treat with this important resource, which is our future. I am concerned that in the last paragraph of her presentation, she says the following, and I quote, "It is strongly advised that in all new legislation concerning children, the country act out of an abundance of caution. If we choose to walk into the world of SOGI, which I will explain, let us do so with eyes wide open. The relevant authorities are urged to revisit the Child Protection Bill, reconceptualize its purpose, review and revise the language so that the provisions of the bill are consistent with a well-reasoned national stance on sexual orientation and gender identity." It is my view that this bill is much more and needs to consider much more than our stance on sexual orientation and gender identity. This bill is about the future of our children. This bill is how we consider and protect the one fundamental resource that is critical to our future, our children. With those words, I'm obliged, Chair.
Thank you, Senator Brathwaite. I do recognize Senator King.
Madam Chair, we are at 16 minutes past 11, and I would like to move a motion that we extend this particular session by 15 more minutes. By no more than 15 more minutes.
Is there a seconder? Seconded by Senator Rogers. So, Dr. Evelyn, we have some further time that we can engage with you, because I think having heard CPC and Senator Brathwaite, you may wish to respond. I also recognize that Senator King wishes to make an observation.
Thank you, Chair. Dr. Evelyn, I just want to make this observation. In your submission, you have made reference to other jurisdictions all the time, in where you have the concerns. The last time I checked, sovereign states have the right, and put that in inverted commas, to decide what they are going to allow or not allow based on their own cultures and their own understanding of who they are and things like that. I get a sense that you are preempting what Barbados is doing, and I get the sense that your fear comes from the fact that you believe, I'm saying as simple as humanly possible, that this would just be a follow-fashion approach in terms of how maybe we've seen a lot of things happen in the world before. I haven't gotten anything from reading the bill, looking at the things that gives me that same impression. And you made the point that people interpret things differently. I just want you to also bear in mind that you mentioned the Bible when you said that we were Christians, and you would agree that even in terms of religion, people interpret things differently all across the globe, coming out of the same books, the same things. So I said that just to say that laws, if laws were not written in such a way where you have different interpretations of different things, then there probably would not be any need for lawyers, because there'd be no need, because everything would be just set straightforward, and that's how it would be. That's not how the world works, and I'm sure that you would appreciate that even in sociology, that one may have words or definitions that people in different parts of the world will interpret differently. So I just want to say to you that I fully appreciate your concerns, although in some instances, I do not agree that we are not clear on a lot of the definitions. The two times that you mentioned the parts of the bill where you talk about the UN and the other things, the representative from CPC had to go over it twice. But you can't take it it will be out of context if you don't put the full things together. And that is all I would like to reiterate as we go through these particular discussions. And I'll go back to the Bible again. If you took the Old Testament by itself, without putting the New Testament with it, there are things within the Old Testament that you would probably wonder what kind of a God is this, especially in the laws themselves, where you have things where you can stone people and all of these different kind of things. So we have to take everything in context as to how it is built out. And I just want us to be cognizant of that as we go forward in these discussions.
Thank you. I'd like us to look at Barbados as is. We really have to see where we are. And we talk about sovereignty, and it sounds good. And I would love to see us emerge as really sovereign. But the truth is, sovereignty is not what it seems. Take, for example, what has happened in Uganda. You know, we are cash-strapped. And in the throne speech, the Governor General said it. You know, we do not trade with ourselves. We do not give ourselves money. And therefore, there is that sensitive relationship with the international community. And to some extent, we have to toe the line, call a spade, so that we are not able to just do our own thing. It has to be in context. Let's go back to the children, because that's what we're talking about. And I remember in 2002 doing some research, actually in 1994, doing an epidemiological study with the Ministry of Health. And I went home shaking because I did not need to wait for any results and any analysis. I could see clearly what was happening. And in 2002, you know, we have NIS reform, and it's even getting further now. Look at Barbados. Now, our children are our only real resource. We don't have many natural resources. We don't have financial resources. Our people are our resources. We are about 80,000 to 100,000 people short because we've had a rate of 1.6 for far too long. When you consider the labor sector, what is happening is that we have a widening dependent sector and a narrowing productive sector. And that is why, like in 2002, it was projected that by 2015, whereas at one time it was 3 persons who were working, supporting one non-contributing member. By 2015, they said, you know what's going to happen? 1 contributing member is going to be looking after 9 non-contributing. And now it's even worse. So that when we look at our children, we have to be really, really careful with what we do. I listened to the news last week where they said there was a 300% increase in the cases of autism. Consider our children are exposed to a lot. In primary school, they're using drugs already. So that what we have to do is to just do what the charter says: love, care, protect, heal. We have to preempt things. Now, I heard persons who I thought would know better saying, oh, this isn't happening here. That's silly. We can't wait for it to happen. We have to be wise. We have to punch above our weight. We have to see what is going to happen and take those children and carve them and mold them and help them. Because, as I said, not me, experts, your brain isn't fully developed until you're in your 20s. You make all kind of foolish mistakes when you're young. And so we should be in our schools teaching our children how to manage themselves, how to control their emotions, how to have that self-control in all areas, not just sexuality, but sex and drugs and eating, yes, because of NCDs. We have to have a real appreciation of our children and recognize that when 30 years from now, how many of us around this table are going to be here? But those little preschoolers are going to be the ones sitting here, and the 18-year-olds, one of them might be prime minister. So that my concern in looking at this and in understanding that there is a move towards social change based on this whole notion, non-scientific notion of sexual orientation. When your neighbor's house is on fire, you wet yours. Barbados, we need to wet our homes. What sexual orientation? The World Health Organization says it has to do with sexual preference, attraction, and behavior. In that context, we have to save our children, save them.
Thank you, Dr. Evelyn. And I think that we found ourselves at this stage where we are likely to be going over or reiterating previous comments that we have made. What is clear from your submission is that there's a definite concern of yours that the committee recognizes is a concern that ought to be examined. However, the bill before us, in terms of its title, what it seeks to address, it does not contemplate the handling of the issues to the extent that you have articulated them. The perhaps it may be useful to have the policy of the government restated, because the bill and CPC has been very clear on it at section 5, or taking the purpose at 3.2 along with section 5, has been very clear that the concerns of gender assignment or sexual orientation in the way that you have expressed them are not, do not square, or will not be provided for, or will not be allowed within the bill as it is outlined. So you have a concern, but your concern is not really a concern that's reflected in the bill, because the bill does not speak to it in the way that you have articulated it. The bill does not allow the state to assign gender, or the state to make determinations on sexual orientation. So what I think you could probably be calling for is for government, if it has not been made plain enough, to restate its position on gender assignment. But so far, insofar as we are examining the bill on child protection, I think that from the engagement up to now and from the clear responses of CPC, that it can be concluded that the concern, though relevant, is misplaced within the context of the bill. And the issue of sovereignty and the concern about Barbados being bound by the different instruments to which it has signed on to, that also has been clearly addressed, with the recognition that up to now we don't have any reservation, and that has been reiterated by CPC and so on. But even if at some point in time those instruments change in a way that there needs to be reservation, in a way that does not reflect what we have committed to in the Charter of Barbados, in a way that does not reflect the care and protection of the child, in a way that Barbados as a sovereign state contemplates it, then we can submit reservations. And I'm sure that we will submit reservations, because Barbados continues to be that country that sees itself as being friends of all and satellites of none. I don't know if there are any members of the committee in the 29 and a half seconds that we have available to us that would wish to offer another question or observation. But since I see none, it is my task and responsibility to thank you. Certainly, it has been food for thought. What you would not be privy to would be the contemplation and consideration of the written submission, where we look quite extensively at the cases that were proposed to you, which you put before us, which you put before us for consideration. And during those deliberations, the committee considered that your submission was indeed a relevant concern that I'm sure that you and many others would have, but that the concern, it would take the bill a little outside of the scope and contemplation that has been, or indeed remains, before the Parliament of Barbados at this time. So I take this opportunity to thank you and Ms. Edwards, who has been supporting you. Thank you for responding to the request for submissions. A number of people have offered public commentary, but have not gone further in responding, so that we can have this very important engagement. So we thank you for coming and clarifying your position, engaging us, and hope you have a wonderful day. I'm sure there will be an opportunity where we would respond further as we examine the other considerations and the other presentations and bring the matter to close. So thank you very much.
Thank you too.
Okay. protection bill will be the bill, once it is passed, that will replace the existing Child Care Board Act. And so the members of the committee, the Joint Select Committee that is tasked with the responsibility for examining the Child Protection Bill and the Child Justice Bill, I would introduce for your benefit at this time, Ms. Richards. We have, and going around from my left, we have Senator, I almost said Senator Richards. We have Senator Rogers, Senator Brathwaite, Ms. Cynthia Ford, and Deputy Chair of the committee, Mr. Senator King, and myself as Chairman of the committee, Tony Moore. We are the members of the committee. We have the Honourable Corey Lane. Okay, he was online, but he's not online at present. And here this morning in attendance to at least participate in these discussions will be your line minister, so he needs no introduction, nor would your permanent secretary, Mr. Wiltshire. Ms. Richards, I would wish to turn over to you at this point in time to introduce the members of your team from the Child Care Board, and then you can get right into your presentation, which I'm sure you have been informed shall be contained to about 15 minutes, subject to the flexibility of the chair.
Good morning, Madam Chair, and good morning to the members of the Joint Select Committee. My name is Roseanne Richards, and my team is, to my immediate left, is Mr. Colin Sinthill, the Deputy Director of the Child Care Board. To his left is Ms. Carla Haynes, and she's a Senior Child Care Officer with responsibility for residential care. To her left is Ms. Julia Davis, and she's a Senior Child Care Officer with responsible for the Child Abuse Prevention Program. To my immediate right is Ms. Roxanne Sanderson, and she's the Senior Child Care Officer with responsibility for foster care and adoption. And to her right is Ms. Regina Dale, Child Care Officer. Child Abuse Section.
Thank you. You may proceed. Welcome, everybody.
So the Child Care Board in its present existence is responsible for the care and protection of children, and as we presently operate, we operate under Cap 381 of the laws of Barbados. The new child protection legislation, me and my team, or my team and I, we are eagerly looking forward to it being passed into law, because this new child protection bill offers us lots more to work with as practitioners in the field of social work, looking after the care and protection of children. However, while the Child Care Board has been an integral part of the process of developing or devising the new bill, which was laid in Parliament in May, subsequent to that bill being laid in Parliament, there was a lot of public comments, and we as the practitioners, our ears were to the ground. So we listened, and we went back together as a team to look to see how else we could make it not only user-friendly to us, but satisfying to the general public based on what they were seeing. My team, when we discussed it, some of the suggestions that came up, we didn't get a chance to go back. Well, I shared the information with my PS through his minister, but I think a lot of the information that came out, some of it would have to be referred back to the drafting committee so that some of the information could be amended in the proposed bill when any changes are made. So some of the things that we had highlighted that we thought should be considered, the first one was the fact that in the international scheme of things, child care centers should be changed to child protection facility, as internationally, a child care center refers to daycare facilities or day nurseries. So that is one of the changes having discussed with my team. that we thought that could be considered. We also felt, and this would go back to the drafters again, that abandonment and desertion should be defined and a time frame for desertion should be included. Because when we heard well, not specifically this particular thing, but when we heard the comments of the public and some of the things that they were saying on the call-in programs, even in the marches, they think that we would have too much responsibility and their responsibilities would be diminished. In relation to section 19.5 of the present bill, the word moral is included. And we felt after discussion that could be, and the draft is here, we felt that could be removed and just leave it to read, a child in need of care and protection where the child is, or where the child has been exposed to danger, and the moral could be removed. But the drafter will be able to speak to that. In relation to section 19.5H1, does not or refuses to obtain treatment. So I should read the section again. Page 19. And it starts, child in need of care and protection. A child is in need of care and protection where the child suffers from a mental, emotional, physical, or developmental condition that requires treatment to cure, prevent, or ameliorate the effects of the condition or harm suffered, and the parent and one does not or refuses to obtain treatment or. So the concerns were raised regarding responsibility, and it was suggested by the team, if a child is hospitalized, the hospital should act rather than call on the child care board. And the reason why that comes up very often is because as we presently operate, when children are in our care or when a child goes to the hospital to be treated, I think the hospital as a medical facility might have a lot of ability and responsibilities that they could use to determine, based on their professional and their mandate, how a child should be treated. Sometimes when parents don't show up or parents refuse, then they call on us, the child care board, to make a decision. And my team wanted a bit of clarity, so I suppose that that is something that we could discuss as well. And the question here, when a child is hospitalized and the parents refuse to give permission for the child to get medical treatment, who is responsible? That was the question of the team. And in relation to that, the follow-up was, clarity needs to be provided on the role of the Queen Elizabeth Hospital and the Child Care Board as it relates to medical neglect, because these are concerns that are being raised. As it relates to the removal of a child by the director, and we're now moving to section 31 on page 40. So, as it reads right now, it says, where the director has reasonable grounds to believe that A, the health or safety of the child is in immediate or imminent jeopardy, and B, there is not enough time to apply to the court for an order under section 32, the director may, if necessary, with the assistance of the police and without need for further authority other than conferred on him by this section, enter any place or premises where the child is believed to be present or to reside and search for it, locate, and take the child into custody. And we had discussed this at length in the discussions leading up to the drafting. But having gone back and spoken to my team, they're still concerned, and we've all agreed that the word may should be replaced by shall to give everybody a comforting position to work with. In relation to section 39, section 30, and this is on page 39, going back a bit, but action taken by the director. This might just be a typo, but it is felt that the word plan should be inserted before care. Section page 30, section 36. So, page 39, sorry. Section 36. Page 6 is, page 39. It should be A, care plan. So, sorry. A, sorry, not 6. That was a typo on my part. So the director may decide against taking any action where he considers that proper arrangements exist for, it should be the care and protection or care plan. Is that the right one? No. Is that it? Be an error and we're trying to locate it.
Are you referring to page 39, clause 29(6)?
29. It has care.
That care plan, where a care plan is developed pursuant to subsection 2B, that care plan shall be signed by the parent.
Yes, please.
So then it will be section 29(6).
Thank you. And the final issue that we want to reinforce the provisions as it relates to section 33, page 42. Residential Protection and Treatment Center Order. So Section 33 of the Child Protection Bill makes provision for a residential and treatment center order. However, the Child Care Board in its current form is required to admit into care children who exhibit severe behavioral and emotional issues, conduct disorders. And we continue to deliver the services we have in our present circumstances, but more and more we are seeing children coming into care who are either developmentally delayed, they have not been taken care of in terms of their medical treatment up to the time, and they're displaying extreme behaviors. We would continue to care for them, but we acknowledge that in our current establishment, as we stand up right now, we are beginning to prepare for the amalgamation of 4 social service agencies. When these 4 social service agencies come together, we will have a new entity. I'm not sure what the name of that new entity would be, but the Child Care Board would be no longer the Child Care Board in its current form. And we are accepting that going forward, we would need to make provision for that treatment facility to treat those children that would be coming to us with these developmental issues or challenges that we see the extreme behaviors that we have to deal with. And we are saying that while we know that provision is being made for the new entity, we want to be able to deliver services with sufficient manpower and training for the staff for us to continue to treat these children when they come into our care. Because obviously the fact that they're into our care, it might have been a situation where there might have been a bit of neglect or the parents were not able to source or do what they have to do to help them in that stage. And we think that when they come to us, we want to be able to make them better than they were before they came to us. So to conclude, I would say that my team and I, from the Child Care Board, we are eagerly anticipating the passage of this new legislation, because not only as practitioners, but if I were to put another hat on, the level of care orders that we're now exposed to in this new legislation gives us much more room to do what we have to do to better protect and care for the children of this nation. Thank you.
Thank you. You may proceed as well, since you have the floor with the comments on the Child Justice Bill.
So in relation to the Child Justice Bill, again, my team and I looked at it, and the issues that were raised in relation to section, page 18, section 6.1. Let me just find it. Where is it? Page 18, section 6, the word 1D. 1D. The word beliefs need to be clarified, and the reasoning behind it is because there are persons who are of religious belief, there are people who are from faith-based organizations, there are persons who have other beliefs. So we figured that some clarity to that could be of assistance. And then reference is also made, another concern, that throughout the Child Justice Bill, reference is made to a secure residential treatment facility. And the team is saying that this needs to be clearly defined. The facility needs to be identified for protection and treatment. Definitions and examples are required. For example, children's home, secure protection facility, and secure treatment facility. In addition, a secure treatment facility is needed for children who present with the mental health issues and/or drug abuse or drug-related issues. And the final comment from the team is that timelines should be identified for the execution of court orders. But one of the things that I would like to suggest as a person who would have practiced law, we are having the bill laid, and I know that most times legislation or bills come with subsidiary legislation, and when we get the subsidiary legislation, more things will be outlined as the day-to-day policy and practice, and therefore, as social work practitioners who are relying heavily on the legislation to help us deliver in our day-to-day duties, we also look forward to receipt of the supporting subsidiary legislation or the regulations that would help us throughout the process and make it more accessible, not only for us, but for those persons who want to be going online or even buying a copy of it from the government printer that they can read and see for themselves what it is that we are going to be applying to the care and protection of children in our Barbadian society.
Thank you, Ms. Richards and team. I turn over at this point to the Chief Parliamentary Counsel for comment.
Chair, just to reinforce the points that the Child Care Board would have been one of the major stakeholders in submitting comments or the germination of a lot of the policy in relation to the drafting of the bill, so that at the appropriate points, then there would have been opportunity to submit. But in as much as you are submitting now, I will respond in relation to certain things. In relation to the Child Care Center, in terms of the nomenclature, that can be done. And once we have the approval of the pilot ministry in relation to the nomenclature, that can be done. In relation to abandonment and desertion, those will take the ordinary dictionary meaning attached to those words. However, if there is a time frame that is needed for desertion, that is a policy issue that needs to be pointed out and given to the ministry so that the draft then can include such details. In relation to the inclusion of the word moral, again, policy issue, which needs to be communicated in the ministry, and then we will make the necessary removal. as it relates to the does not or refuses to obtain treatment, or in terms of the responsibilities of the Child Care Board and the QEH. Remember how this section is supposed to be interpreted. It is supposed to give the context in which the intervention of the state is to be made, so that the intervention of the state is articulated by talking about care and protection and what it is supposed to be defined as. So that clause 5.1, a child is in need of care and protection where, and then it states the situations where their intervention will be necessary. As such, then all the actors, including the director, would need to make a determination in terms of the role they will play in assessing the suffering from a mental, emotional, and physical and development condition. If it is that there is another actor that needs to be included in that decision-making, again, that is a policy decision that has to be communicated to the pilot ministry. Thank you. In relation to clause 31, just one moment, I just need to go to that. I will pass on to the Minister for his comment in relation to this matter. Chair, through you.
Minister, you have the floor.
Thank you very much, Chair. Thanks to Child Care Board for coming and for reviewing the documents subsequent to the original conversations. This particular clause was one that benefited from perhaps the most extended and intense conversation. Whether it had to be a case where the law should say shall, that a police officer shall be present, or may. This really was perhaps the one piece in the legislation that we discussed the longest. I recall the original position by the CPC was that it should say shall, that a police officer shall be present. But I also recall the position by the consultants who were assisting with the drafting, and then the original position of the board, that perhaps may, because there may be circumstances where it is so urgent and that there's no police officer present, that it is so urgent that there's a need to act. And then the advice also came from persons who were in social work before, who also said that there could be circumstances where you could remove a child. It may not necessarily be confrontational, but if you say you have to have a police, you cannot act at that time either. So the may allowed you to go with the police. The may allows you to go with the police and to act. But shall would mean that you're limited in acting if there is no police present. But may allows you to go with the police. And that had been the position that caused the original draft to change. So it would be interesting, Madam Chair, through you, to hear the new position of the board.
Before the director responds, and I make a disclaimer for my my lack of knowledge to sometimes the English language and the language of the law. Because I was wondering, as I heard the submission from the Child Care Board, whether they were saying the director may enter any place or premises where the child is believed to be present or to reside, or the director shall. I thought that the question of using the word may or shall related to whether or not they can enter any place or premises, or as opposed to whether it related to the police, because I thought that the words "if necessary" related to the assistance of a police officer. It's just like where the punctuation is, that the director may, comma, subject to those things, and those things plain in there, but if you put ... enter any place or premises where the child is believed to be present. So the Child Care Board should clarify the concern that was raised in terms of the use or shall versus may, what really is the concern? And then for the chair's benefit, the drafters, or maybe before the child care board comes in, if you, Ms. Bell, can clarify as written here, what the clause really is saying.
Chair, okay, and I am communicating, also taking into account the discussions to which the minister referred, so that the original advice from CPC, as would be recorded, is that the use of this particular type of provision would have been unnecessary in the sense that you could apply for an emergency protection order. Okay? We did have a meeting in which it was impressed upon me that there were circumstances, in fact, that were so critical that you needed to intervene, and you would not even have time to apply to a court, even though the proceedings would be ex parte, and that would be using an emergency method to apply. We then went through a discussion of making sure that it wasn't a situation that would be arbitrary, which is why in A and B, it specifies the specific circumstances in which you can intervene in this way. The child has to be in immediate or imminent jeopardy, and there is not enough time to apply for the court under Section 32. Those were the parameters to limiting, so it is not even an arbitrary intervention. On top of it, in order to remedy the fact that you did not go to the court in the first place, it specifies in Clause 31(2) that you are to go to the court within 24 hours and to make sure that you make the application. And you are to inform the court to apply to the court, and you are also to inform the parent, in which case then you would offer the parent the time to appeal. So that those are the situations with which you are supposed to tie and clinch this particular provision that could potentially be arbitrary, but is tied down specifically because you can only apply them in these very, very specific circumstances. And I just wanted to share that. Thank you.
So when we discussed as a team, initially the point that you were making, Madam Chair, about the removal of the exclamation. So yes, so the amended position that we were putting forward, that Act 31(1) be removed if necessary from the director may, and put the director may, if necessary, with the assistant, ... That is what was the position that was put forward. However, the whole concern behind this particular section from my team was the fact that as practitioners going out there to enter and remove, they felt the need that there should be police presence, because in most circumstances, while the law gives us the authority to do what we have to do, the concern was that the police should be there to ensure that there's no interference with us performing our duties and doing what the justice or the law requires us to do. So that was that situation. I see, Miss
Chair, but as a practitioner, you would put in place the necessary mechanisms for how you would execute your duties. And it was, the mayor was only, and we have to go back to the discussion, the mayor was only to give you flexibility, right? If it is that you wanted to, and please note, the CPC had issued the warning in the first place, okay? So it must be acknowledged. Okay, good. Okay, right, it just means that you would have to be communicating and saying that your position has changed and you want the police officers to be there. But the fact of the matter is, as a practitioner, you can bring them because the maid doesn't stop you from bringing them if you need that.
So I take the point, but again, my team has often said to me that when a call is made to the police, we're supposed to go X or Y place to do X or Y. Sometimes we are often told we don't have a police, we can't go, and because of I know what I said prior, but I have to be fair to my team as well as what it is that we're going out there to do.
Senator Rogers.
Thank you very much, Chair. And I wish to thank Mrs. Richards and her team for the work that they're doing. I'm not a student of English, but I'm wondering if the may and shall may be referring to different things here, and we're having two different conversations. Because I get the impression that the Child Care Board says the director may enter any place, he may, but they're entering the place with a police officer. Is that what you're trying to say? That a police officer must always be with you when you're entering a place, but you may enter, not shall.
Yes.
I get that's the impression that I'm getting here.
Minister Humphrey.
Sure. Just to clarify, the discussion we had was exactly that. And it came down to, in the absence of a police officer, can the board act or not? And if we're saying that, there are two things. If we're saying that they can only act if the officer is present, it would mean in the absence of a police officer, they cannot remove a child, even if the child is in immediate danger. The position put forward by the team at the time, including the Child Care Board, was that there could be circumstances that are so egregious that require immediate action. And then the point that was just raised by the director, which is that oftentimes in the old order, a police may not be available. It would mean that if a police is not available, the Child Care Board definitely cannot act, and it worsens the reality for the child. The other thing is this: we've had, however, conversations with the police force and the police service, and they have asked us for meetings, to have a meeting and protocol so that they could better understand their new responsibilities under the law and to make themselves more available to the board in these circumstances with that new understanding of the law. My concern, having been influenced by the conversation, because originally my position, having worked at the Child Care Board, was necessary. It was always the case that a police shall be necessary. But then there were social workers, one in particular, who raised the point that he visited the house and saw a mother hanging her children on nails, for example, and he took down the child and moved with the child. And in that case, what we would be doing would be so limiting that an officer would not be in a position to move. And then the compromise we made is the one the CPC suggested, which is that in circumstances where you have to act, then within 24 hours, you have to go and justify your position before the court and to prove, as laid out here, that it was in relation to the health or safety of the child being in immediate or imminent jeopardy. So that by allowing us to say, if necessary, you can act even if a police is not there, but it is in the board's interest to always seek to have a police officer present.
I think that perhaps I'm hearing the conversation being influenced by another hat that I wear from time to time. And I'm hearing a concern being raised with the safety of the child being paramount, but also the safety of the officer who has to go and remove the child from the premises. And I'm hearing that there is a comfort level with the presence of a police officer. I'm also hearing by CPC's explanation that the director may, if necessary with the assistance of a police officer, that's also suggesting that the safety may be assured without having a police officer present. And I'm wondering if that's making provision for private security or so on, my layman's view of things. Because, I mean, it would be in response to the concern that is not being outwardly expressed, that we are hearing clearly that officers of the board need to be protected when going into premises because they don't know what they're going to be confronted with.
Chair, no, what I was actually saying was that as a practitioner, there's nothing preventing you from bringing the officer with you. If it is that you need to, but the context of the discussion was whether you would be prohibited from acting in the specific circumstances if the officer was not available. So those are the parameters, and if it is that you're feeling the comfort level, of course, that's a policy decision, but just understand that you will be restricted in the acting, right?
Any other comments on this one from members of the committee? Because what we are hearing is a very delicate balancing of obligations and responsibilities and of who is protected at all times as well. I do recognize that Minister Abrams wants to make an intervention.
Thank you very much, Chair. I think it is critical in situations like this that the response must be flexible, or the ability to respond must be flexible and determined by the situation. Once we put the word shall in there, it removes all flexibility. There are some circumstances that require immediate action, and shall be accompanied by a police officer is going to remove the ability to act in that circumstance. It would pretty much make a nonsense of an immediate response capacity. I believe that the practitioners are trained. They deal with situations. They can evaluate if it is safe to do so, and the interests of the child so require, then you should have the ability under the legislation to take your action. If you do not think that the circumstance is conducive to you going in alone, then you should have the ability to contact the police. But the flexibility must be maintained in a way that it will not be if the word shall is used. That's my 2 cents.
So, having heard all the comments, and I'm hearing from my team that we should revert to what is there. I thank you.
Out of an abundance of caution, the team at the Child Care Board, having reconsidered, is satisfied that the language, the director may, should remain.
Please.
May, comma, if necessary. Thank you.
Chair, just to continue with the review, the word plan, well, it is recognized that this refers really to clause 29(6). And so if you read where a care plan is developed pursuant to subsection 2B, that care plan, so the word plan should be inserted. So we recognize that. It needs to be inserted. Thank you. In relation to, just trying to, in relation to clause 2, which makes provision for the residential treatment care center, of course, this particular section was subject to discussion as well, and the main insertion that would have been new was in relation to what happens to the 12-year-old, the person who is less than 12 years old who commits very serious offenses and then has to be dealt with because they can't be dealt with under the criminal justice system. You would then have to deal with them under the child care system, and the residential protection and treatment center was supposed to be the area where the facility where such persons would be dealt with. There's also the significant threat to others, and then in need of care and protection as defined by the clause 39, which is really 40, so that needs to be dealt with in terms of the reference. But in terms of extreme behaviors, this is where this is a new limb that would have to be introduced, and this is a policy matter. So if it is that we need to introduce a new limb, speaking to children with extreme behaviors, then we would need to intervene. However, I would draw your attention to clause 5, which speaks to where a child is in need of care and protection, and in relation to the same, where you have the mental treatment and physical development condition, where the parent may refuse to obtain treatment, or, you know, there is an unavailability in relation to consent for services. Where there's a mental, physical, or developmental condition, the question was whether it would actually fit under there, or actually under any other limb that is there, or if it is that it should be properly dealt with specifically as its own limb. My view is that perhaps we can give you a concession in terms of providing its own limb, but it would then have to mean that clause 5 as well as clause 33 would have to be amended to reflect that. And again, this would be a policy decision. In relation to the Child Justice Bill, we speak to the word beliefs. Again, that takes on the ordinary dictionary meaning of beliefs, and it is wide. It would then contemplate as wide as possible an interpretation, because you don't know what those particular things are. And so in that way, you would then have to appreciate that there needs to be as wide as an interpretation as possible in order to contemplate the many beliefs that people have. In relation to the use of the word secure residential facility, your attention is drawn to clause 2, in particular on page 16. Secure residential facility means a residential facility described under section 68. We then have to go to section 68. As you can see, the shoulder note says secure residential facility, and in fact, part 10 speaks to secure residential facility and speaks to the management, administration, and operation of those facilities. But in particular with 68, it provides how this secure facility is supposed to be interpreted. So it means a residential facility designated under this act for the purposes of the assessment under clause 8, detention of a child prior to or after initial inquiry is conducted under this act, detention of the child pending trial pursuant to clause 40, so that's the overlap between the child protection and the child justice. A reception and rehabilitation of the child who has been sentenced to a term, and we were saying that we would not refer to imprisonment but detention, or a like type word under this act, and residential protection center for the purposes of reception and rehabilitation of children who require psychiatric or psychological treatment or treatment for substance abuse pursuant to Section 40 and Section 70. So Section 40 deals with the overlap with the child protection, while Section 70 specifically provides for the intervention where the child may have an episode or something like that, and in which case then there can be something done. So it includes the residential protection and treatment centers, but right, and it would be considered for the purposes of this act. But you can see that there is a clear delineation of what is the secure residential facility would be. Okay, so if there are other issues, but you can also see that there was an attempt to speak to the treatment of substance abuse. In terms of the timelines identified for the execution of orders by officers. Now, you would have made allusion to this, but I would draw your attention to specifically, and crave your indulgence, Chair. Clause 114. This act comes into operation on the date to be fixed by proclamation. So that this gives time for the regulations to be made in relation to specific areas of this bill that need to be properly operationalized in the minutia, right, procedures, and so that would not be the best dealt with a piece of legislation coming into Parliament, but more at a lower level with these subsidiary legislation, which can be more easily changed, right? But because it does not come into operation immediately, it gives institutions like yours the chance to prepare for the new regime that will come in as introduced by the child protection and the child justice legislation. And the regulations are also drafted during that time. And then shortly after proclamation, then the minister will make the regulations and they will come on stream so that they can be operationalized in the fullest way. So those are my responses in relation to the submissions of the Child Care Board. Thank you very much.
Senator Brathwaite.
Thank you very much, Chair. As I reflect on the submission by the Child Care Board, and I thank the team for coming and sharing their thoughts with us this afternoon. On the second page of the presentation, referring to page 42, section 33, the comment is made the Child Care Board in its current establishment will be part of a new arrangement entity. Therefore, it is being recommended that provision be made for the creation of a secure treatment facility which will cater to children with extreme behaviors. This may require additional staff and training. Chair, my question is, does this mean that this law will not be approved and promulgated until such time as there's approval for the provision of a new secure treatment facility, new staff and training? Or are provisions already made for these facilities to be available?
Chair, it makes provision for those things to be put in place. There's some things that are already in existence, and if you would recall, in the review of the child justice bill, in relation to the specific provisions, you would recall that the reformatory schools would have been considered for the purposes of this legislation to be secure residential facilities. So that those systems already are in place, but the bill also contemplates that there would be need for other facilities to be established. And also, as I would have articulated just now in relation to the bill not coming into operation until all is ready, that is not an unusual situation. You don't want a situation where you proclaim the bill and then everybody is like scattered and don't know what's going on and all that. Right, it gives all entities an opportunity to prepare themselves so that when it is then fully operational, they will be ready. It does not mean that it has to be forever. And in fact, it does not contemplate forever. It just means that it would give you the chance, or give the institutions the chance, to put the necessary measures in place, including the regulations and including any administrative matters that need to be taken into account, including staffing and infrastructure. Thank you.
Senator Bradford.
I just made a comment, Chair, in the context of the enthusiasm that can arise by staff seeing the possibility of a reformed institution, new arrangements, new facilities, and new opportunities for them to grow and to develop. And where you have a delay in the implementation of decisions that are made, this could have a negative impact on morale and on the enthusiasm of staff. So I was just wondering whether, in fact, there's a coordination of actions in terms of the legislation and the provision of the facilities that are necessary for the implementation of the said legislation. Those were my reason for my comment.
Chair, well, as you can fully appreciate, CPC is not in charge of that. It is the line ministry, the pilot ministry, that would be responsible for that. So Minister Humphreys would be here in relation to that coordination of all the entities and all the things that would be needed, including the instructions for the regulations, although in anticipation of this matter, the office had put forward before some recommendations into the direction, but it is the line ministry, the pilot ministry, that is responsible for coordinating all of that. Thank you.
Okay, just for clarity. So there were two centers being proposed. In the child protection legislation, we were considering the residential protection and treatment facility, which would be in relation to persons who were under 12 and under, who would have committed a crime, and persons who, having had conversations at the initial stages with the magistrate informally, maybe somebody that they divert to this particular facility. There was another facility which was a secure residential facility for persons who would really have committed a crime, who traditionally would end up in one of the penal institutions like DOTS. So there are two facilities. In relation to the residential protection and treatment facility, this is meant for those children under 12 and persons who are not really criminals, but who perhaps could have been hungry, committed a crime, whose, when you look at these circumstances, there's reason to give them an opportunity that does not bring them into direct contact with the system, the justice system. And the current reality of Child Care Board is that they cannot cope with this, because even some of the children now who are at a certain age exhibit such deviant behavior. And some sent their way to court, but exhibit such deviant behavior that is outside the capacity of the persons who work in that system to give them the necessary care and attention. It is very clear that we need a separate facility. And we have already started looking for a facility, a place where we could establish as this residential protection and treatment. The idea here would be to treat to the issues of the child and therefore not criminalize the child. And in that facility, hopefully we'll be able to offer the level of care and assistance and service that they need. So and it is not contemplated at present that the staff at the Child Care Board, as currently constituted, will be able to do this. So we know that we're going to have to hire new staff. We know we're going to have people with different competencies, and it also eases the board because there are currently some children in Child Care Board who really should not be there because they exhibit such behaviors that they're not fit for there, but they're not criminals. And therefore, this facility makes, in that context, a lot of sense, but it's going to be separate from that secure facility for persons who would have committed a crime, a more serious crime.
Sorry, just for clarity, just to remember that the child protection is being piloted by the ministry. I'm trying to remember the full people empowerment and elder affairs, I'm sorry. And then in relation to the child justice, it would be home affairs and information. So they would be responsible for putting those things in place. Thank you.
During our examination of written submissions, there was one particular submission that made reference to diversion. The Child Justice Bill, starting at section 33, makes reference to a process of diversion. As it stands, the process contemplates that a magistrate will have initial meetings with the child to determine if diversion then should become necessary. One of the submissions proposed that this is putting the cart before the horse, and it would be better if not a magistrate, but if a board with trained specialists like yourself, social workers, psychologists, and so on, would be put in place to determine whether diversion is necessary to alleviate a child having to stand before a magistrate and having to be in the system. Because although, as the bill is currently outlined, there's no intention for anything used in that informal process to be used against the child further on, it was proposed in a written submission that it would be better for a board to consider the particular case and then to determine whether or not the process of diversion could apply. What is your view on that as practitioners in the field?
The written submission that was put before you in relation to having that particular child seen by a board as opposed to going before a magistrate. I have not practiced criminal law, so I don't even want to go there, but one of the things that I would want to say, while it might be useful, I think that how our courts are presently set up, we have a juvenile court, and children who come into conflict with the law, they are seen in the juvenile court. I also recall that in instances where I've gone to the juvenile court and matters relating to children, that the court, whoever's in the precincts of the court, they are asked to exit the court while the particular child's situation is dealt with. And I think that we have magistrates in our system who speak to children not just in the capacity of a magistrate, but as that caring professional. So I would want to give it further thought before I just come to say, well, a board should be established and it shall not go before a magistrate. I mean, there might be instances where you might be able to look at both, but as it stands right now, I wouldn't want to say, well, have a board. We don't have a board yet. Right now, we deal with magistrates, and I could think of a few magistrates who have, even a few judges, who have spoken to children in that care without using that against them or in the scheme of things. But I would want to say that I would want to give it more thought or discuss it more momentum, and the fact that we don't have a board. And if it's something that we could write on and deliberate further on, we could submit that at a later stage.
Well, up to now, we have been hearing CPC respond that some of your proposals should be the subject of further policy decisions coming to them. So I just raised the question because then it may be entirely possible where there's not currently a board that it could be a policy decision coming out of these discussions that maybe a board is necessary for that purpose. And this is not to say that some magistrates, as you've said, would not speak to children in a caring way, but I think the background of the submission was that a child shouldn't have to be in the court system at all until it's established that the particular case needs to be in the court system.
Yes, Chair. And I feel the need to reiterate, the bill makes it clear that the initial inquiry in which the diversion decision will be made is not to be considered to be a criminal proceeding or proceeding. And in fact, it is even stated within the bill in terms of the diversion that it is designed to prevent stigmatization and the consequences flowing from the subject to being before a criminal justice system. And also, it would prevent the child from having a criminal record. So that is what the initial inquiry and the diversion mechanism was supposed to facilitate. In terms of, again, and I raised a point in our discussions of the written submissions, the magistrates are given guidance in terms of how to conduct these initial inquiries, including the fact that they have to be conducted in an informal way and in a child-friendly way. To the extent that magistrates also operate within the juvenile justice jurisdiction of their jurisdiction, they would have the training and experience to deal with children. And in as much as the bill makes it clear that this mechanism is not to be considered a part of the court mechanism of procedures, it makes it clear throughout. And that at no time during that period would it be considered a record. And so I needed to take the time to emphasize and also to understand the model that was placed and the fact that it was embraced by all stakeholders, which would have been included the Child Care Board. Thank you.
Minister Abrams?
Thank you, Chair, and thank you, Ms. Bell. I think we have to be careful of adding layers or unnecessary layers to a process. I believe the concerns of all can be addressed by ensuring that the magistrates have very specific training that put them in a position to deal in a humane way with these interventions and these inquiries. Now, if we try to divert or subvert the jurisdiction of the magistrate, you start to look at other broader constitutional issues. If somebody is arrested by the police or in custody, police is supposed to be before court in a reasonable time, that sort of thing. If you actually start to add layers in that, then we might find ourselves in a complicated process, and we may actually hinder the same process we're trying to improve upon. I do believe that everyone, with the coming into force of both of these pieces of legislation, I believe that everyone at every level has to be trained appropriately for the tasks that they're expected to carry out. And I believe a lot of the concerns can be addressed in ensuring that the magistrates who have jurisdiction over these children have the requisite training. If everyone is satisfied at that, right, then the other issues don't necessarily arise. If everybody understands their role, our role is to keep the children so far as possible out of the formal judicial system. Our role is so far as possible to keep them from having to go to a trial. If everybody understands that and is trained with that in mind, right, and I don't mean just legal training and judicial training, I mean they must undergo some sort of child psychological type training, then I believe that those concerns are more than adequately addressed I'm very hesitant to add further layers, because then if we just keep piling layers to cure a problem, we can have an unwieldy system. So I hear you loud and clear. And if you actually go into the juvenile court now, you realize the policy right now with the magistrates or those who deal with children is as much as possible to try to resolve the issue as opposed to send a child through a trial. So everybody knows what we're trying to accomplish with these pieces of legislation. And I do believe that training those who are involved in the system cures most of the ills, other than putting other layers on.
And since I don't see an indication for any further comment, I do see an indication from the Deputy Chair, Senator King.
Thank you, Chair. I think one of the things that we miss here, though, when dealing with that particular submission, I think the author of that submission was not speaking specifically to the inability of the magistrates or any of the persons involved to handle children in a particular way. I think they were making the point that the environment itself, exactly where you are going to do the interviews, are we going to do it within a judicial or a court system or wherever, and then having a child then know that the person, one of the persons in it is actually a magistrate. And I think the point that Mr. Hobbin was trying to make is that he felt that psychologically, just having a child before a magistrate would create some sort of a problem. And I just want us to be clear on that aspect of it.
That's even though it's clear that the magistrate doesn't have to see the child in court. It may be out of court, but the very fact that it is before a magistrate.
But once again, we go back to the question, how did the child get there, right? If the child is coming to the attention of the magistrate, it means that a criminal act has been committed. So we have to measure what we're doing with our systems. So there's a process. Once you engage the attention of the police pursuant to a criminal act, the next step is before a judicial officer. If we attempt to pull that jurisdiction away and put another layer or a group of persons, then it has implication for the whole structure of the criminal justice system. Now, I hear you loud and clear, but we still need to treat it with the seriousness which it warrants. So we recognize that we are here pursuant to criminal act. We don't want you to be here. You don't want to be here. But as you are here, let us deal with it in the most child-friendly way, while allowing you also to accept that it is a serious situation that you're dealing with. Having said that, we're going to have to work it out one way or the other.
Thank you, Minister. And with that, I'm definitely now not seeing any further indication for an intervention at this time. So I wish to thank the Child Care Board for, first of all, reviewing the pieces of legislation, having sat as a party to them. I noted with interest that you indicated, hearing all the public comments and so on, you had your ears to the ground, because very often when we are in a process, sometimes you have to step back and listen to see where there might be areas for further tweaking. And the submission this morning certainly reflects that was the stance that your team took in reflecting on the two pieces of legislation before us for discussion. We do take on board the fact that there are some things that may be relevant, the issue of diversion, the definitions, although we accepted that they're ordinary dictionary meanings, whether there needs to be clarity, for instance, as it relates to desertion and time frames and so on. And all these will be taken on board, and we anticipate that you will be submitting through the line minister so that CPC gets the final guidance that it would need to address these matters. And one important thing came out, that was the concern of the committee as well, was that the time between these pieces being passed in Parliament and then the proclamation, that it should be adequate enough to address your concerns that you raised and those that were reiterated by the CPC, that all persons will have sufficient time. That's in the courts, the child care board, which will not then be the child care board, but all establishments will have the time to be trained into how to give full implementation to the pieces of legislation, and that further users in the community and so on would also be sensitized as to the changes in the pieces of legislation. So again, I thank you very much for taking the time to present to us today and for taking further time to reflect more fully on some of the exchanges that we have had. Thank you.
So on behalf of my team and I would like to say thanks for accommodating us.
You are most welcome. So that brings us to the end of this submission. And we have one final presentation to consider as part of this session, and that's with the Bar Association of Barbados.
Recording stopped.